Now, going to segue, if I can put it that way, to a gentleman who's dedicated a good part of his life to challenging systems like the one that we're experiencing in Cook County. So I'd like to ask Alec Karakatsanis to please come up here and make his presentation. He has been involved in many parts of the country challenging the constitutionality of systems like the one that may be in place here in Cook County. So thank you for joining us, and please, Alec.
Thank you, Commissioner Garcia. My name is Alec Karakatsanis. I thank all the commissioners for listening to my perspective on this devastating and entirely unnecessary system of wealth-based detention in Cook County. I'm a civil rights lawyer and the founder and executive director of an organization called Civil Rights Corps, a nonprofit civil rights organization that, as the council member suggested, has been going around the country and filing federal constitutional class action civil rights cases to end the system of wealth-based human caging. I have filed nearly 20 major constitutional civil rights challenges to the use of cash bail to keep impoverished people in cages in nearly 20 jurisdictions around the country. I'm also co-chair of the American Bar Association's Committee on Pretrial Justice. But today I'm just going to speak in my personal capacity. You all know the troubling statistics. I won't spend much more time going into them. We have 2.3 million human beings in cages on any given night in this country. We have 12 to 13 million people every year in this country that we place metal handcuffs on and take into our cages and process through our system. We put black people in cages at a rate 6 times that of South Africa at the height of apartheid. I think it's impossible to understand Cook County's cash bail system without putting it in that broader context. The cash bail can't be understood without understanding the criminal legal system as a system that needs to efficiently process those millions of bodies from their homes and schools and churches and families and communities into cages. And that is the main reason why you've heard in testimony earlier today that the average bond hearing length is 37 seconds in Cook County. It's impossible for our society to process this volume of human beings into cages and give every person the dignity and respect and individualized attention that every human being deserves. Perhaps no element of the American criminal legal system is as senseless, as wasteful, and as abominable as the American cash bail system. On any given night in this country, there are 450,000 human beings who are sitting in an American cage just because they don't have enough money to buy their way out. We tolerate this system of cash bail without any empirical evidence that this everyday brutality disproportionately visited on black and Hispanic communities in this country is doing any good. This is intolerable. For over 50 years, every major panel of law enforcement, academic, judicial experts has condemned the system of money bail. And yet, when we go home at night, several thousand people in this county will be in the jail, unable to return to their families and jobs and communities, be stuck in a cage paid for by Cook County taxpayers just because they're too poor to come up with an arbitrary amount of money set in probably 37 seconds. All of us who tolerate this system will be responsible for the jail assaults and deaths, broken families, jail rapes, the infectious diseases that spread in our jails, the thousands of coerced guilty pleas for people who claim that they committed a crime even though they believe that they're innocent just to get out of jail, and the tens of thousands of new crimes that people commit because they were kept in pretrial custody. We now have robust statistical, empirical research from the Arnold Foundation and from the University of Pennsylvania which shows that a low-risk person who is put in jail for just 2 or 3 days, 48 to 72 hours after arrest because they can't afford bail, is 40% more likely to commit a crime in the future just because they were kept in jail prior to trial. That makes sense, right? You heard the testimony just a few minutes ago. Being put in jail can cause you to lose your home and your job and your children, and it creates instability, and instability is what leads people to commit crime. We're all responsible for that. And last year, Cook County taxpayers actually paid for 81,000 extra days in jail, what the Sheriff's Department calls dead days, for people that were kept in jail prior to trial because they couldn't afford bail for longer than they were actually sentenced to after their conviction. They were turned away when they got sent to state prison, saying, "You've already served too much time." Over 1,000 people had that happen to them in Cook County last year. So normalized has this everyday brutality become that most judges who routinely use cash bail in Cook County do so in hearings that last seconds or minutes without any rigorous intellectual or evidentiary consideration of alternatives available to them or to the cycles of trauma and suffering that they perpetuate. I would love to hear judges respond to the testimony they just heard from these people who've been impacted by their decisions and what I hesitate to even use the word decision to describe, this sort of everyday habitual routine that they've become used to. Most people who live in Cook County have no idea that all of this is being done in their name. Now, we're winning our cases all around the country because there's no reasonable justification for keeping people in jail solely because they can't make a monetary payment. In the past 2 years, numerous federal judges have issued judgments condemning the use of financial conditions of release that result in detention because of a person's poverty. When cities and counties come into court against us, they really have very little to say on the merits of our claims. It's very difficult to justify putting a human being in a cage because she can't make a payment. I've seen it in dozens of cities all over the country, and I haven't seen any convincing argument presented in court at all countering any of our claims. Not only does treating two similarly situated people differently because of the amount of money that one person has in her pocket make no sense under the Equal Protection Clause of the 14th Amendment, but constructing a system that makes such an important decision that affects people's lives in the way that we just heard, based on money without any rigorous consideration of readily and less costly available alternatives, also violates the Supreme Court decision that Judge Morrison referenced earlier, United States versus Salerno, 1987 decision in which the Supreme Court said that putting a human being in a cage before finding her guilty of anything should be a last resort and imposed only in, quote, carefully limited, end quote, exceptional situations and when all else fails. Rarely does an issue have such widespread consensus, though. The absurdity, unfairness, and unconstitutionality of the cash bail system has been definitively condemned by the American Bar Association, the Department of Justice, legal scholars, police chiefs, public defenders, prosecutors, even the Cook County Sheriff, who sees firsthand every single day the trauma and brutality inherent in human caging. The Cato Institute, the leading conservative think tank, filed a brief about the unconstitutionality of cash bail in one of our cases in the 11th Circuit Court of Appeals in Georgia, and a long line of presidents and attorney generals and distinguished judges. In 1965, at the height of the federal movement to end cash bail in all federal courts, including the District of Columbia, Justice Arthur Goldberg from the Supreme Court said, and I quote, "If it is true that the quality of a nation's civilization can be largely measured by the methods it uses in the enforcement of its criminal law, then the American bail system as it now operates can no longer be tolerated. At best, it is a system of checkbook justice. At worst, a highly commercialized racket." That was over 50 years ago, one of the leading Supreme Court justices saying that the system can no longer be tolerated, and yet every single day it is tolerated by all of us, all over the country. The following year, President Lyndon Baines Johnson reiterated those concerns when signing the landmark Bail Reform Act that has transformed Judge Morrison's jurisdiction. The defendant with means to afford can pay bail. He can afford to buy his freedom, but poor defendants cannot pay the price. He languishes in jail weeks, months, perhaps years before trial. He does not stay in jail because he is guilty. He does not stay in jail because any sentence has been passed. He does not stay in jail because he is more likely to flee before trial. He stays in jail for one reason only. He stays in jail because he is poor. There are hundreds, perhaps thousands, of illustrations, President Johnson continued, of how the bail system has inflicted arbitrary cruelty. And all of us are responsible and complicit in this because we have tolerated for the last 50 years since President Johnson spoke those words of tolerating that arbitrary infliction of cruelty. Attorney General Bobby Kennedy also said when testifying before Congress about the Bail Reform Act, "Plainly, our bail system has changed what is a constitutional right into an expensive privilege." All of these historical condemnations of the cash bail system have one thing in common. They identify the central brutality of keeping a human being in a cage solely because she can't make a payment. In Chicago in 2016, I read in the local paper the other day that on the night that we all go home tonight of this committee hearing, there'll be several hundred people in the Cook County Jail who are there because they can't raise less than $1,000. We should ask ourselves what kind of a legal system creates those outcomes, tolerates them, justifies them, and then reproduces them day after day. What kind of a system, moreover, does so without any empirical evidence that this everyday brutality visited, as we heard from Professor Jones, disproportionately on the black and brown communities of this county, is doing any good? The answer, in my view, is a local legal culture that has utterly lost any sense of what a kind of thing it is to do to put a human being in a cage. And I think the responsibility lies with all of us, especially the judges who do it every day without thinking. So the Supreme Court said 30 years ago, as Judge Morrison said, in our society, liberty is the norm, and detention prior to or without trial is a carefully limited exception. As a result of that holding, the court also held that nobody can be kept in jail unless extremely strict procedures are followed, and if the person is such a risk that no other combination of conditions can mitigate those risks. Otherwise, people have to be released on the least restrictive possible alternative. So I want to address something that came up at the last panel. We have to be incredibly vigilant as commissioners and as members of our society and our local legal community that the coming end of cash bail, and make no mistake, I do see it ending in Cook County, either because of actions taken by this commission or the legislature, or if need be, our constitutional civil rights class action lawsuit that we filed here, which I believe to contain unassailable legal claims under the equal protection and due process clauses. We have to be very careful that the system doesn't morph into a new kind of oppression. It doesn't morph into massive new restrictions on liberty and expanded surveillance through onerous pretrial supervision conditions. We can't create a world in which communities of color are filled with people wearing electronic monitors, tracking their every step. The end of cash bail does not mean the beginning of an Orwellian supervision complex. Do not be seduced by slogans like risk assessment or electronic monitoring. We must go to work every day to ensure a basic constitutional principle, and we must never let it leave our heads. No restriction on another person's liberty can be imposed unless I have really good reasons for it. That's what it means to have a free society instead of a society that talks about freedom. Luckily, we have a wide range of alternatives. And one other note to just highlight something that Judge Morrison said, we have to be very, very careful that ending cash bail doesn't turn into a system of overwhelming without bond detention. These judges who are used to throwing people in